Chapter 10 talks about how we manage and supervise sex offenders in the community. So many policies that are related to sexual offending are enacted after there's been some high publicity, emotionally charged sex crime. And the goal then becomes for people to try to protect the community from recidivist sex offenders, so repeat offenders, by increasing punishments and regulating their behavior. But when we look at these laws, we find that most of them are not very effective, although there's only been a few evaluations, and most laws are memorial laws. The primary focus of laws have been registration and community notification laws, and that includes the Jacob Wetterling Act, the various Megan's laws, the Adam Walsh Act, residency restrictions, GPS tracking, and lifetime community supervision. So Washington State has the first comprehensive modern policy, and it's called the Community Protection Act, and it was enacted in 1990. Provided 14 provisions for punishment and monitoring of sex offenders, and two high-profile cases prompted this law. One is Wesley Allen Dodd, who sexually assaulted and murdered 3 young boys, and said that he would reoffend and he would enjoy it. The other was Earl Schreiner, who had a 24-year history of sexual violence. He kidnapped a 7-year-old boy, assaulted him, cut off his penis, and left him for dead. Both had finite sentences, and the state was not allowed to notify the community about their release. In 1994, the Jacob Wetterling Crimes Against Children and Sexually Violent Offender Registration Act is enacted, and this is the first registration act. 1989, 11-year-old Jacob was kidnapped by a masked man while riding his bike with his 10-year-old brother and 11-year-old friend. There's actually a podcast about this case, and the offender was actually literally months ago, in the summer of 2016, actually identified and caught. Jacob was never found, but many speculated he was killed by a sex offender living in a halfway house in town. Jacob's mother, Patty, led an effort to implement sex offender registration both in Minnesota, where the assault happened, where the crime happened, and later nationally. And in 1994, Congress passed this law. It requires states to create a registry for sex offenders, and if they fail to do so, they forfeit 10% of their funds from the Omnibus Crime Control Act. In 1997, they passed some amendments to this. The offenders must register in the state in which they work if that's different from where their residence is. So if someone lives in Massachusetts and works in New Hampshire, they must register in both states. They set up procedures for registering out-of-state offenders. And so if you look at the Massachusetts Sex Offender Registry, you can see, if you look at some of the offenders, you can see that they had out-of-state convictions. It directed states to participate in a national registry and gave states discretion to include additional offenses that weren't originally specified in the original act. In 1996, we have our first Megan's Law, and it's named after Megan Kanka. She was 7 years old in 1994 when she was killed by Jesse Timon-Quandas, a recidivist offender. And the parents felt as though the community was entitled to be notified that these offenders were present in their community. This law was passed 98 days after her death in New Jersey. And then in 1996, we enacted a federal version. And by August 1996, all states had some law, with Massachusetts being the last one to do so. The Pam Lyncher Sex Offender Trafficking and Identification Act is also from 1996. Pam was attacked while showing a home. And then there was some lobbying for tougher sentences for violent and sexual criminals. This law established the National Sex Offender Registry. This is overseen by the FBI. They verify addresses of offenders, disseminate information about them, run background checks, and they have various powers to supervise offenders. In 1998, we have the Protection of Children from Sexual Predators Act. This enabled the Bureau of Justice Statistics to assist states in complying with registration. It specified the offenses and penalties for sex offending and focused on trafficking and internet crimes. In 2000, we have the Campus Sex Crimes Prevention Act. It says sex offenders must notify institutions of higher education that they attend for school or employment. So if somebody is either a student or is employed at a school, they have to notify the school that they're a registered sex offender. That information then is provided to law enforcement agencies in the jurisdictions, and schools could request that information at any time. It also amended the Higher Ed Act to require institutions to provide notice of how information concerning registered sex offenders could be obtained. In 2003, we have the PROTECT Act, and PROTECT stands for Prosecutorial Remedies and Other Tools to End the Exploitation of Children Today. This enhanced methods for investigation and adjudication, which is trying of sex crimes. It allows us to intercept wire, oral, and electronic communications related to sexual assault and sex trafficking. It created a national Amber Alert program, and it decreased pretrial release for offenders charged with certain crimes involving children. It also decreased the authority of judges to provide reduced prison sentences to certain types of sex offenders. And enhanced the penalties for child abduction to a minimum of 20 years, and increased the penalties for production of child pornography from 15 to 30 years. Strengthened provisions on virtual child pornography, and lifted the 25-year statute of limitations for sexual and physical abuse. It created a 2 strikes law, upon which the second strike, the offender is given lifetime imprisonment. And it authorized supervised release for offenders for life, and this is applied to people who have committed offenses against children. In 2006, the Adam Walsh Child Protection and Safety Act was enacted. This is the law that's actually named after 29 victims, 28 of whom are children, and the 29th is a woman from Massachusetts. It sets national standards for registration and community notification, civil commitment, child pornography prevention, and internet safety. It also makes failure to register a deportable offense for immigrants. The law also established grants to empirically assess the legislation, and it created SORNA, which is the sex offense. I forget what SORNA stands for. It also creates the SMART Office, which oversees state compliance with SORNA, Sex Offender Registration and Notification Act. And the requirements are retroactive, which is something that's a little bit controversial because they apply to people who had broken the law before this law existed. States that don't comply risk losing 10% of the burn law enforcement assistance funding, and as of 2012, only 8 states were compliant. And that's because complying with this law is very expensive for most states. For most states, it would cost them more than the 10% in funding that they lose, and it's not really considered to be best practices in dealing with sex offenders. So let's talk about registration and community notification laws. So what happens is states assess levels of risk, and often there's 3 tiers of offenders, but some states only have 2. Massachusetts uses 3. Everyone is notified about a tier 3 offender. Select groups are notified about tier 2 offenders, although in Massachusetts, tier 2 offenders or level 2 offenders convicted after a certain date, everybody is notified about. And offenders have a time period during which they must inform the registration agency of their whereabouts. So depending on the tier that they were placed on and the offense of which they were convicted, that determines how long they have to register. Generally, they have to provide the registration agency with a photo, fingerprints, home address, place of employment or school, and in some states, a DNA sample. They verify the address by sending a letter that must be returned within a specified time period. And failure to register is a violation of the law and results in a separate sanction. The requirements vary by jurisdiction, and they vary based on the type of offender, how retroactive laws are applied, the length of registration, the time period in which they must register, as well as the process for being removed from the registry. Jurisdictions vary on how they assess risk, method of notification, sanctions for failing to register, and how they handle juvenile sex offenders. So the primary argument here, as far as a legal challenge to registration and community notification, is that registration and community notification is a punishment. This means, as a punishment, it violates the double jeopardy clause, the ex post facto clause, a bill of attainder, and cruel and unusual punishment. So double jeopardy protects somebody from being tried twice for the same crime, and ex post facto, the ex post facto clause says we cannot subject somebody to a law that was enacted after the crime was committed. Bill of attainder talks about inflicting punishment without judicial process. The courts have addressed these in several key cases, and they've basically said no, none of those arguments apply. So in Doe v. Ports in 1995, they made some modification to judicial review processes for Tier 2 and Tier 3 offenders. And they said that you can employ preventative measures for means of protection, and as long as they're reasonably designed only for the purpose of prevention and not punishment. And so the court said that basically is remedial and not punishment. Therefore, retroactive application is acceptable as a means of achieving community protection. They also said if the laws were not applied ex post facto, it would take years to offer the protection it is designed to provide. Another issue concerned applying these requirements retroactively to people who plea bargained. So several offenders appealed and asked to withdraw their guilty plea, but the court upheld the duty to register. In an opinion of the justices to the Senate, Massachusetts said there is no constitutional requirement to notify the defendant of the duty to register prior to when the defendant enters a plea. Doe requires the states to establish specific guidelines by which the degree of risk of a further offense can be determined, focusing specifically on Tier 2 and 3 offenders. So notification to the community is allowed only when members are likely to encounter the offender, and it's usually based upon geographic location. Courts have been split on whether registration and notification triggers a due process analysis. So in Russell and Stearns v. Gregoire, they said there's no protected interest. And in Artway versus the Attorney General of New York, they said registration does not trigger a protected interest, but notification does. And Doe recognized different rights based on tiers. Courts often quote Paul v. Davis. The government could publicize records of official convictions as long as this does not impede a person's freedom. Thorough analysis of reputation as a result of publication of an arrest record. Reputation alone was neither liberty nor property by itself sufficient to invoke the procedural protection of the Due Process Clause. In Doe v. Pataki, they said registration and notification does not deprive someone of the right to equal protection. There's an inevitable loss of anonymity, and the state has a strong interest in public disclosure. Also in Doe, they said that these are rationally related to a legitimate state interest, which is, of course, protecting the community. In 2003, SCOTUS decided, which is the Supreme Court, decided two cases. Connecticut Department of Public Safety versus Doe and Smith v. Doe. And in the first, they said an injury to reputation alone is not a deprivation of liberty. And in the second, they said these laws are constitutional even if applied ex post facto because the law is not punitive. So the real thing that kind of hangs up here, and we see this with civil commitment as well, is that the courts have basically said it's not punishment. These are regulatory, and they promote states' interest in preserving public safety. Some other issues that the courts have addressed is how a sex-based offense is defined. So, for instance, what about kidnapping, sexting, and public urination? How it applies to special classes like people who are homeless and juvenile offenders. The broad scope of internet notification, and risk assessment. So in terms of risk assessment, it's critical to accurately assess risks in order to match risks and needs of offenders. And prior to the Adam-Walsh Act, states had discretion here. Some did it based on the offense, and others did it based on the offender. When it's offender-based, they use actuarial assessments, which are risk assessments that are used by like accountants and life insurance. One of the problems with this is one of the things we know about risk assessment is that it's often based on static traits, static factors, things that don't change. So if those things don't change, like you have already committed an offense, that's something that's not going to change about you, then your risk is not going to change. AWA requires offense-based risk assessment, and that's one of the most significant controversies of the law. So looking at actuarial ones, this interprets a standardized score on a risk assessment instrument, and it's based on both static and dynamic characters. Early studies really focused on static characters, but assessment of both is really important. What we should really need to focus on is the characteristics that we know are associated with recidivism. So people have evaluated a variety of different tools and have found that several of them are capable of predicting general violent and sexual recidivism, whereas the PCLR cannot. The Static 99 focuses on 10 items: whether or not male victims are present, marital status, non-contact sexual offenses, unrelated victims, stranger victims, prior sexual offenses, current non-sexual violence, prior non-sexual violence, 4 or more prior sentencing occasions, and whether the offender is 25 or younger. And then this can be used to put them into 4 risk groups. So we never say someone has like a 75% chance of reoffending. It's always that they're low, moderate, or high risk. And you can see here from the Static 99 that they have both moderate low and moderate high. One thing to think about here is these were standardized on Canadian and United Kingdom samples that were predominantly white, so that may mean that these are not applicable to U.S. samples or racially diverse samples. The strongest predictors of recidivism, and actually the strongest predictor for sexual recidivism, is whether or not you've broken any law beforehand. So they tend to be criminal lifestyle variables, poor social support, attitudes tolerant of sexual assault, antisocial lifestyles, poor self-management strategies, and difficulties complying with supervision. The static 99 has not been able to predict juvenile sex offending or sex offending by the clergy. We can also take a conviction-based approach. There's no empirical studies on this. Most offenders would be considered to be moderate or high risk under this because we're looking solely at what have they been convicted of. So let's talk about the Adam Walsh Act. So Adam Walsh has 3 tiers. Tier 3 is punishable by at least 1 year in imprisonment, and it includes sexual and aggravated sexual abuse, offenses against a minor under 13, kidnapping, and some other Tier 2 offenses. Tier 2 is punishable by at least 1 year imprisonment and includes sex trafficking and enticements, transportation with intent to engage in criminal sexual activity, abuse of sexual contact, use of a minor in a sexual performance, solicitation of a minor for prostitution, and production of child pornography. Tier 1 then includes all other offenses. High-risk offenders have to register for life, moderate risk for 25 years, and low risk for 15. If you fail to register, that's an additional felony charge and an additional 10 years in prison. It also expands notification for all sex offenders, and so this means that the community can't really discern who poses the most danger, which was the original purpose of these laws. It also applies notification to juvenile offenders, which goes completely against the philosophy of the juvenile justice system and is not supported by any empirical literature. Most juvenile offenders do not become adult offenders, and we know that risk assessment for juveniles is not accurate. It also removes the discretion of states to use risk assessment best practices. So best practices are those practices that have been determined by empirical research to show that they actually work. So basically, this is telling states you can't use what works best, and this compromises public safety. Legal scholars call this law misguided, harmful, overly broad, constitutionally questionable, and potentially harmful to juveniles. As I mentioned, it's named after, 17 victims. Okay, and the regulation is based on the idea that location of offenders' residence is linked to the location of their offending. Right, so we're notifying people based on where someone lives. You register in the town you live in, the town you work in. Yet nearly all of the victims after which the act is named were abducted, violently sexually assaulted, and killed by strangers. And in a sample of 224, only 16 offenders live within a mile of the abuse location. So for cases like Jessica Lunsford, Polly Klaas, and Elizabeth Smart, which are 3 of the most famous sexual assault cases, notification would not have worked. It's likely that most states, as I mentioned, will not enact this because it's too costly. It requires system development, reclassification, expanded enforcement, and additional costs. And most are also just refusing to enact it based on principle, knowing that it is not best practices. So there's no single way to measure whether or not these laws are effective, and outcomes can be interpreted differently. Does an increase in offending actually mean an increase in offending, or does it mean a greater awareness and more reporting? We know that rates of domestic violence, rates of sexual assault increase during certain time periods, but it also happens to be time periods where people became much more aware of these as crimes, and so it's probably really an increase in reporting. So the goal of registration and notification is to reduce the amount of sexual abuse, but it could lead to an increase due to collateral consequences. Okay, so what happens is people get collateral consequences are things that also happen to you as a result of your punishment. So registration and notification, residency restrictions, and some research finds that these actually increase someone's risk for reoffending. Most studies find that there isn't any support in reducing recidivism, that there's few significant differences regarding recidivism, and we don't really know how this impacts juveniles because there haven't been sufficient studies. So how about how this affects the public? Public safety, which is a goal of these laws, should be dependent on the protective behavior they take once they find out about offenders in their community. But there's not much research on this. And additionally, few community members are aware of who lives in their community, and few take any precautionary measures. So let's think about collateral consequences. These are consequences other than those intended in the law. This results in high levels of social stigmatization, lots of relationships, employment, and housing, and many sex offenders have been assaulted as a result of vigilantes. These offenders then are more likely to live in socially disorganized neighborhoods. Social and financial constraints probably increase recidivism. And so it may be better to restrict notification to public safety officials. Notification also increases public fear and makes victims less likely to report. It skews a sense of safety due to the fact that most of the public misperceives who sex offenders are. And sex offenders then become likely to live in clusters due to residency restrictions. So residency restrictions are based on the idea that geographical proximity to offense opportunities increases the likelihood of offending. So if I tend to offend against children, maybe it's not a good idea for me to be near schools or daycares or parks. It typically bans residents within 1,000 to 2,500 foot distance from schools, daycare centers, parks, playgrounds, and other places. More than 30 states have such legislation, but it's usually done at the local level by towns. And other states began enacting it, figuring that if nearby jurisdictions enacted these laws, those sex offenders would converge upon them if they didn't have these types of laws. So there's a higher percentage of child sex offenders lived within 1,000-foot buffer zones around schools than did non-child sex offenders. But research doesn't show us that closer proximity to children actually leads to higher levels of offending. So basically, one thing that does happen is these restrictions create barriers that make it hard for offenders to reintegrate. When people are having a hard time reintegrating, they're at higher risk to recidivate. So this increases them being transient and homeless and may cause offenders to move further away from supportive environments and employment opportunities. They may lose their homes or be evicted. So only 27% of space in the city of San Diego is actually available for sex offenders based on these residency restrictions. This leads then to the emergence of these colonies where sex offenders live, but there's also no restrictions on whether sex offenders can live next door to or with children. They're not necessarily restricted from spending time with children, and 62% of a sample said if they wanted to reoffend, they could. So these residency restrictions don't necessarily prevent somebody from reoffending. One other way we monitor and supervise offenders in the community is through GPS monitoring. This is active real-time tracking information. There's also passive monitoring, which just basically uploads at the end of the day. A hybrid model transmits after longer periods, but alerts authorities instantly if offenders are out of range of where they're allowed to be. So Florida requires all convicted child sexual abuse offenders living in the community to wear GPS for the rest of their lives. These cost up to $15 per day, and there are additional costs for the supervision agents. This doesn't prevent any crimes from occurring. It cannot detect if a sex offender is accessing inappropriate material at home or abusing someone within the home. And so far, we don't see any significant difference in recidivism or technical violations. But it does reduce the level of absconding, of people fleeing the jurisdiction. Okay, there's also what's called a containment approach. This is a victim-centered collaborative strategy amongst parole, probation, law enforcement, treatment providers, and victim service agencies. And it has 5 main components. One is a philosophy of community and victim safety, where they're focused on recovery of the victim, ensuring appropriate employment and housing for the offender, and removing offender from the victim's home. It also provides case management that's tailored to the individual needs of the offender, a multidisciplinary approach, so that means different partners that are involved in both the offender and the victim's life, so criminal justice, treatment, etc. Consistent public policies, and quality control, so evaluating the goals of community protection and restorative justice. Make sure it's actually working. Colorado's been a leader in these strategies. They created the Sex Offender Management Board. It represents the Department of Corrections, Department of Public Safety, Human Services, Public Defender, DAs, treatment providers, and other relevant stakeholders. And together they develop guidelines for treatment and supervision of sex offenders based upon research. And they're committed to research-based best practices. Minnesota and Washington State are also leaders in this field. And so these states did not implement the Adam Walsh Act because it is not best practices. So they're aiming to balance the needs and rights of sex offenders with the community. What about reentry and reintegration? We know that being successfully reintegrated to the community is a key to reducing recidivism for all offenders. Much research in this area has found supervision and management policies to have a negative effect on reintegration. And in particular, there's 3 things we have to consider. One is housing for the offender, employment in school, and recreation and social activities. In terms of housing, residency restrictions may affect the ability to obtain affordable housing. So most communities don't want sex offenders living in their neighborhood and may mobilize to push them out. This means then that they're frequently relocated to less desirable neighborhoods, which makes it difficult to find and maintain employment and may mean they're moving further away from any support and treatment programs. It also creates emotional distress and leads to higher levels of absconding. So a lot of times sex offenders will just move and then not notify anybody. It's difficult for felons to find jobs and even more so for sex offenders, yet we know that employment is a critical need of reentry and reintegration, and it's one factor that's absolutely correlated with recidivism. Employment is also a social tie to the community that's been linked with desistance in adulthood, but sex offenders are also prohibited from working in certain jobs. Registration and notification requires that school officials be notified about students who've committed a sex offense. Whether or not that information can be released to other students, so is controversial. But the Adam Walsh Act will make juvenile sex offender information public. We also know that social ties assist reintegration, but in terms of recreation and social relationships, we have to be careful because some events may bring sex offenders in close proximity with children. We don't have a lot of guidance on this, but we also have to remember that we cannot completely remove sex offenders from society, short of incapacitating them for life. And that wraps up this chapter on management and supervision of sex offenders in the community.